The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15, Sunday afternoon at 1 o'clock, again on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. My number here in Des Moines is area code 515-276-3956, and John's number, area code 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that stands for Child Protection in Iowa, and that forms the boundaries of the major efforts that we have in influencing public policy as it relates to child protection issues, and also relates to the assistance that we give to people who count on us to give them a few hints when they are having difficulties with the Department of Human Services and the juvenile court. We've looked into the statutes, we've looked into the rules, and we've worked with many families with some degree of success. Once people understand what their parental rights are, they can begin to exercise those rights and begin to argue those rights before the court and before the individuals in the Department of Human Services and one other place called the Iowa Department of Inspections and Appeals, which does some of the legwork as far as fact-finding in these various cases. Don, there is an effort on the part of Iowa fathers and others to bring about some awareness, maybe that's an overused term, as to the plight of parents who do not have equal access to their children. Something's happening over in mid-June over at the Supreme Court. Can you tell us a little bit about that, Don?
Hey, yes, you're referring to the group Iowa Fathers. It's a support group set up for both fathers and mothers who are having visitation problems and other issues along that line. Once a month on the second Thursday of the month, they've been holding a meeting here in Des Moines at 6 o'clock in the evening. So John and I support the cause, and if anybody here is listening that needs support along that line, you can contact us and we can tell you where the meeting's held. We got a email here for an upcoming activity, I'll call it. It's going to be held June 13th, a rally at the Iowa Supreme Court building. That would be just south of the Capitol here in Des Moines. The email says, "Greetings. Our brothers and sisters at the Des Moines chapter have scheduled a rally at the Iowa Supreme Court building on Friday." Oh, I told you, I said Thursday. Thursday is when the meeting will be held, Thursday night, and then Friday, it says here, June 13th, in the morning, starting at 9 a.m., they're going to have their rally. So we encourage everybody that has an interest in the loss of their children and poor visitation, issues like that, to attend the rally and come to the meeting that's held once a month. Yeah, the email goes on. It will be in support of planned protests around the world for Fatherless Day. Mentioned Fatherless Day. That's coming up. But also, as I said earlier, the group totally supports women when they are unjustly hurt. Our primary focus as a group will be joint parenting. Children need both parents. And also, they've taken on the cause of the Hansen ruling is wrong. You remember how Judge Hansen ruled several months ago now. Please take Friday, June 13th, 2008, off work and make the trip to Des Moines so that we can show the Supreme Court of Iowa that non-custodial parents care about having equal access to our children and that we have legal rights too. This was sent out by Brian Eel, the founder of Iowa Fathers. John?
Okay. Yeah, fathers have had a tough time in courts because the award of custody seems to favor the female spouse in a divorce situation. Of course, if we didn't have divorce, we wouldn't even worry about equal custody, would we? But sometimes divorce scrambles normal relationships, and unfortunately, the children are in the middle of all of that. And quite often, the custodial parent has the lion's share of the interaction with the children. And what Brian Eel's group does, IowaFathers.com, attempts to influence legislation which would bring some equality in that relationship between the spouses, each spouse, and the children. That's the way it's really supposed to be, and in the best interest of the children, that's the way it really should be. So take off that Friday, the 13th of June, and see if you can help bring about some awareness through marching and protesting and simply demonstrating the need for parents to have equal access to their children. Now, yours is the case, is it not, Don, where you are actually a father without children? I've heard married without children, but you're a father without children, so you can relate to some of these people who with whom we have business, do you not? And you have a story that we tried to squeeze into the last program, but we were unable to squeeze everything into some of these 60-minute programs or 58-minute programs, and sometimes we don't get everything in. Why don't you pick it up from where you left off, Don, and you let me know when you'd like to see a videotape, and we'll see if we can't get it turned on, and you can talk over it, or you can let it play, or however you'd like to tell that story about how you deal over a period of time, how you've been dealing over a period of time with the Iowa Department of Human Services, who seem to have very little concern about fathers, very little concern about parents. They seem to be, at least express some concern about children, but if their concern doesn't involve both children and parents, then we've got a bunch of orphans on our hands, don't we? They call the orphans foster kids. And there are some real problems happening there, too. Okay, Don, why don't you pick up where you left off and see if we can't let people know something about declaratory rulings and your purpose in establishing some relationship with the Department of Human Services, causing them to perhaps follow the statutes. Don?
Okay, go ahead and run the tape, John, while I talk. This is going to be a tape on a hearing videotape by John on May 2nd in front of Judge Blaine. This is an example of what DHS does to many parents. My issue has been going on since 1985. I've been in court several or
These matters are
several
usually held in
times, and
chambers,
many documents have been filed.
Simply argument and not usually on the record. Mr. Burgmaier has requested.
And there have been a lot of parents gone through the same thing as I do. They go to the court, and then they DHS gets the case back again from the district court, and then maybe the parents will try again, or they'll just give up when a judge makes a ruling against them.
On petitioner's application for judicial review filed on September 4, 2007. This is an administrative appeal pursuant to Iowa Code Chapter 17A. In this proceeding, the district court acts in an appellate role and reviews the action of the administrative agency. Here, that is the Iowa Department of Human Services. And that is based upon the record that is made before the administrative agency. The issue that this court may consider at this time must be raised by the petitioner, Mr. Burgmaier, and have been in his application for judicial review. Those are specified in his petition. One, whether the DHS has a legal obligation to respond to the petition for declaratory ruling, that's under 17A.9, and number two, whether the DHS has an obligation to respond to his open records request. Since this is an appeal on the administrative record, no evidence is permitted by the court at this proceeding. Further, by order establishing a schedule for conduct of proceedings pursuant to Iowa Rules of Civil Procedure 1.1603, Parent 2, this court on February 25, 2008, filed such an order and provided the parties with a briefing schedule. The parties then submitted their briefs and scheduled a hearing today, May 2nd, 2008 at 1:30. Present are Mr. Burgmaier, the petitioner, and Assistant Attorney General Diane Staley, and they are here to argue their respective positions. I have reviewed the briefs and will allow you to make your arguments at this time. Mr. Burgmaier, how we'll proceed is that you're the petitioner. I'll allow you to make your arguments. Then I'll allow Ms. Staley to have her arguments, and then you are given an opportunity for a brief rebuttal, and that'll close the record. Any questions on our procedure?
No.
Okay, you may proceed.
This action before us today reminds me of when I made the request for expungement of the abuse report and the resistance I got from DHS to even get a hearing, which then took me to the Supreme Court, which the court today does not have any information on, but the court made a ruling granting me that right. And we're again in court on a different issue, but the resistance is basically the same. The petitioner comes before this court with an alleged reputation of abusing his children. Petitioner has attempted to narrow the issue down in his brief as to how a declaratory ruling should be prepared according to...
Sir, can you please slow down?
The petitioner has attempted to narrow the issue down in his brief as to how a declaratory ruling should be prepared according to Judge Arthur E. Gamble. Gamble also stated that the court is troubled by the department's refusal to review this matter in light of Ms. Wickman's recent admissions. Diane Staley, attorney for respondents, has continued well beyond what Gamble directed the litigants to do. Because of this, the petitioner cannot be properly prepared to argue against many of her false and twisted statements.
Mr. Burgmaier, can I interrupt?
Yes.
I was provided a statement to the court, apparently filed today, and it appears you're reading that.
Correct.
Well, if you want, we can cut this short, because I can just read it to myself. I don't need to listen to you read it to me.
I want to put it on the record, Your Honor.
Well, it's in the record. It's been filed. It'll be in the court file. That's the record that I need.
I understand, but I want to proceed, and then that'll be...
Mr. Burgmaier, I have 500 or 600 cases. I don't need to sit here and listen to you read a statement that you filed with the court. I'm capable of reading it.
Okay, I'll summarize it.
I'd appreciate that very much.
Prior to this report, DHS has prepared a denial of critical care report. At the China hearing in November 1995, the court concluded there was no denial of critical care. It took over 2 years for the DHS to expunge that report. DHS also brought forth a sex abuse report at the China action. The court ruled that there was no sex abuse. Attorney Wickman stated to the ALJ there was no sex abuse. So the petitioner was forced to have a hearing on the abuse report that does not exist. It was 4 months after the ALJ hearing, in 1990, the petitioner ended up with a denial of critical care report that did not exist at the hearing. At that point in time, petitioner requested expungement of the denial of critical care report. That request was denied. In my statement that the court referred to that I filed, I went down through the response that the attorney provided, and I responded and made comments and corrections to what she had done. I concluded with Santosky versus Kramer, a United States Supreme Court ruling. The primary witnesses at the hearing will be the agency's own professional caseworkers from the state and is empowered both to investigate the family situation and to testify against the parents. Indeed, because the child is already in agency custody, the state even has the power to shape the historical events that form the basis for termination. The reason why I put that in there is because DHS all the way through gets to create the history. History starts when DHS takes control. It is not based on the history of the family prior to that. The petitioner has, in good faith, attempted to challenge through straightforward inquiry the means by which the agency has performed and seeks to continue performance in the administrative appeal process.
Can you slow down a little bit, please, sir? Performs and seeks to continue.
Performance in the administrative appeal process. The opposing party is asking the court to depart from a careful review solely on the pertinent statutory mandates for a declaratory ruling. One must ask the opposing party to enunciate clearly what precedence has been set to justify a multitude of references in resistance to a declaratory ruling. The references are clearly outside the narrow scope of the statute, but which claim is made. The opposing party must articulate in a declaratory ruling the means by which one can be denied a clear and proper response to an inquiry process set forth by the Iowa General Assembly. I stand on all the paperwork I've filed. That's all I have to say at this point in time.
Thank you, Mr. Burgmaier. Ms. Staley?
Yes, Your Honor. I think it's apparent that what this case is about concerns a child abuse report that is dated from 1985. Mr. Burgmaier and the department have been in virtually constant litigation since the early 90s on this issue. I would like to address briefly, the court identified two issues that were part of the judicial review. I'm not sure, quite frankly, what the issues are, but with respect to the allegation that DHS has an obligation to respond to the petition for declaratory action, Judge Gamble has ruled that that was denied as a matter of law, so I think that issue has already been decided by Judge Gamble. And the other issue was whether the department had an obligation to respond to an open records request. The petitioner was seeking money damages for failing to respond to an open records request allegedly. And I would note to the court that part of the motion to dismiss filed by the department was that you cannot join an action for money damages with a petition for judicial review. So I would urge the court to find, with respect to the open records issue, that there is no basis to have that heard as a part of this judicial review proceeding. At the time that Judge Gamble overruled the motion to dismiss that was filed by the state in this case, he seemed to have some concern that the petitioner was trying to raise an issue of newly discovered evidence, and that was the issue in the judicial review. The state has, in its brief, outlined all of the times that the issues raised by petitioner have been in a court proceeding, one way or the other. We've tried to give a flavor for the number of times that these issues have been litigated in the record that has been put together. The record is by no means the entire number of cases, first of all, that have been litigated, and certainly not the entire court file, but it does reflect the number of times that the specific issue that Mr. Burgmaier is complaining about has been raised in front of a court or in front of the agency and ruled on. The particular complaint that seems to permeate this case is that Assistant Attorney General Mary Wickman made a misstatement to the court that has somehow prejudiced the petitioner through all these years, and that statement concerned whether Mr. Burgmaier's ex-wife had requested expungement of the child abuse report in question. First of all, that issue has been argued since at least 1992 by Mr. Burgmaier. It has been ruled on by Judge Hutchison, by Judge Novak, I think by Judge one other judge. It's gone up on appeal a couple of times, so it is not a new issue. We have cited in our brief the standard for newly discovered evidence. First of all, it must be newly discovered, it must be material, and it will result in a change to the outcome of the case. None of those criteria are met. This is not new information. Mr. Burgmaier's been aware of it since at least 1992. It's not material. It has nothing to do with the merits of the case. The courts that have considered the issue have all considered it and not made any change to the merits of their ruling. And it certainly would not have changed the outcome of the case. In particular, I'd like to point out that while Mr. Burgmaier alleges that a misstatement was made that caused the administrative law judge back in 1990 to change his mind, actually what happened was the administrative law judge ruled in Mr. Burgmaier's favor. So I don't think that there's any way you can say that it would have affected the merits of the dispute. I believe that our brief and the record that's been compiled in this case sets forth the state's position, and I would rely upon that.
Okay, thank you. Mr. Burgmaier has indicated I will give you an opportunity for a rebuttal argument. You may proceed.
The attorney was stating to the court the names of judges that's been on this case. She couldn't remember Judge Bergeson, I assume. He was the one that ruled against me, and then I took it to the Supreme Court, and he was overruled. And I won't go into detail. I wished I had more time to explain to the court why the decision was reversed at that time to allow me a hearing. Then she concluded by talking about the ALJ in his ruling changed his mind, referring to Wickman's comment, and then he actually ruled in my favor. Basically, that is true, but he did not rule according to what I requested originally. But the court, the ALJ, excuse me, after listening to only DHS witnesses for 2 days, came to his conclusion that there was no abuse. I don't know what more a person has to do to prove their innocence. At this point, I just stand on my paperwork as I've submitted it.
Very well. Anything further?
Nothing further.
Okay, very well then, that concludes the arguments. Thank you very much. We'll consider the matter submitted, and our hope is to get a ruling out within 60 days. So that's what I'll work to do. Okay? Very good.
Okay, John. I've got a few notes here on the subject that I wanted to bring out here. You were listening to Attorney Diane Staley. She's the division director from the Attorney General's office. One of her comments was that the ALJ had ruled in my favor. Well, in some ways he did, totally clearing my name of any child abuse. So I guess you would say that he did rule in my favor. But there were a couple other issues that he ruled against me that I disagreed with at the time. But anyway, that's the way a lot of court actions go. I think the end result was very beneficial to me because the DHS admitted on record, and Mary Kay Wickman, who was the attorney in 1990, stated that there was no sex abuse, and they'd been hollering sex abuse for 5 years, and finally on record they said there was no sex abuse. So they said, you're not going to have a hearing on sex abuse, and she controlled the judge on that. That was one issue she controlled the judge on. So the judge said, okay, whatever you say. No, that wasn't quite his words. He made the decision, the ALJ made the decision to hear it on denial of critical care. And I said, I don't have a denial of critical care report. I'm here on a sex abuse report. The judge said, we're going to have it on denial of critical care. I thought that was very strange when I never had a denial of critical care against me, and yet I was forced to have a denial of critical care hearing.
Let's go back to the decision of the ALJ.
Okay.
The part of the decision that you were quibbling about, even though you got what you call or what Staley called a favorable decision, you wanted not only a favorable decision, you wanted the record expunged. And if there's no child abuse, there's no abusers, why does the state need a record of it? Correct me if I'm wrong, but isn't that what you were after? You wanted not only to be declared a non-abuser, but you wanted the record of that whole situation to be eradicated entirely, correct?
Correct. I proved it with all the witnesses that were just DHS witnesses. I never brought anybody else in. They made their statements, and they proved my innocence, and yet I wonder how much it's cost the state of Iowa to keep that abuse report on record. Okay, I've got some more thoughts on this issue. I served a subpoena on the attorney, Diane Staley. a couple months before the hearing that we had, and I requested that she provide a copy of all documentation, including written, email, and electronically captured data pertaining to the corrective actions that Mary Kay Wickman took to offset the wrongs she committed in a statement to the ALJ at the October 1990 hearing. And she responded back to me. And I'm going to, can we put this up here, John, so they can see a Department of Justice letter? I don't know where the justice is, but that comes from the Attorney General's office, March 28th. And we go down here, and the letter says, "This letter is in response to the subpoena you served on me on March 21st, 2008. I would first note that there are several grounds upon which I could object to this subpoena. However, to avoid having yet another hearing in this matter, I will provide you with a response. That response is that there are no documents. Any communication to the court on this matter would have been orally presented." And it's signed by Diane Staley. Now, John, I want to put up a letter from the Bar Association where I complained to Mary Kay Wickman. It's dated May 8th, 2006. And down here where she's writing here, my name is Renee Herr. I have been assigned to the ongoing investigation of the above listed file. And then it goes on, it refers to Don Burgmaier and his children on a founded case report. And then down below it says, "It is my understanding that during the proceedings in the Burgmaier case, you made a statement to the court that Lynn had," that was my ex, "had not requested an expungement of the A3673. It is also my understanding that you subsequently discovered that you were mistaken and agreed with Mr. Burgmaier that Lynn had requested an expungement." Let me you can leave it right there, John, if you want to. Let me make a comment that Wickman wrote twice to the bar stating that she had made a mistake and that she had corrected it. So this woman from the bar, it's doing the investigation, she writes back and says, "I would like the paperwork to show how you corrected it. What did you do by going to the court, and what court, and all that, to get that corrected?" And then it goes on, "As part of this investigation, I would ask that you provide me with the documentation of when and how you become aware," change the paper here, "that Lynn, my ex, requested expungement of the report. I would also appreciate knowing if and when you made the court aware of your mistaken statement as to the expungement. If you gave notice to the court of this mistake in statement, please provide for our review documentation of when and how you gave notice to the court. We appreciate your continued cooperation and look forward to the requested information and documentation." Signed, the investigator. Okay, John? Now, when I saw that paper, I sent a letter to Mary Kay Wickman and asked that she would provide the information that she sent to the bar, and she had no information to send to me. And I showed you the letter from Attorney Staley just before I read that last one, and she said there is no information. Well, what's that lead a person to believe if Wickman stated in the first place that she took care of the situation, she corrected it, she went to the court, I don't know what she did, but she corrected it. That was the correction that she said she did back pertaining to the 1990 hearing, and to this day they can't even provide any information except to say that they did. Okay, I will go on with my notes here. Now, there was a comment about newly discovered evidence, and that's what brought me into court, was her statement to the bar that she had made a mistake and she had corrected it. So that statement brought me into the what led up to the hearing after it took 6 to 8 months to get there. But anyway, the attorney of record said that this is not newly discovered evidence. Burgmaier Don knew about this at least since 1991. She says this to twist the truth, to convince the judge that this is not newly discovered evidence. This is only 2 years old since the, it was May 2006. I showed you the letter from the bar when they asked, and then later they put out a ruling on this. 2006, now we're in May 2008, so we're talking 2 years. That's not newly, she's saying newly discovered evidence going back to 91 when it was May 2006. I can't understand how attorneys sometimes calculate. It is true that the issue came up in the 1990 hearing. I didn't have a response to it because DHS did not provide me the information. It was confidential. They kept me away from that information. In fact, I went to the Supreme Court on that information, and I was denied that information pertaining to my own children. And so in 1990, I didn't know about this. And then in 1991, thanks to the governor's intervention, I got to see a lot of paperwork, almost nothing on the issue today, but there were 2 papers describing what Wickman had talked about. She had lied to the ALJ, and she continues to lie. I don't like to use the word lie. I prefer to trust people. But look where it's got us to this day. 20 plus years have went by. Okay, my notes go on here to say when Burgmaier was able to extract the information from the bar complaint, it became newly discovered evidence. The newly discovered evidence was obtained as a result of filing a complaint with the bar that Wickman had lied to the ALJ. The bar concluded, based on Wickman's statement in a letter to the bar, that Burgmaier was correct. Wickman again lied to the bar when she stated in her response to the bar on December 15, 2005, I subsequently discovered that I was mistaken and agreed with Mr. Burgmaier that Lynn had indeed requested correction. So now I get one agreement with me that I was right all along, but then they try to twist things again. Well, again, Wickman lied to the bar on May 25, 2006 and stated, quote, I agree with Mr. Burgmaier. Well, that's nice that she agrees, but then she backpedals. Anyway, her statement says, I agree with Mr. Burgmaier, and that as soon as that was brought to my attention, I did my best to correct that statement. Well, the subpoenas, the letters asking, show me how you corrected it. There is nothing. And Staley put in her letter I read to you, there is no documentation. Nothing was done. So I've given you all the information that was done, all the lies that she's put out here. And that's as far as Wickman has gone. She won't correct the situation. How can she correct the situation? Well, one, she could come up on record and say there never was any abuse in the first place. I could go on and on with that. She could have the DHS unfound the report and expunge it. That's what I've been asking for something like 20 years. What more, as I said to the judge in the end, what more can a parent do? You can prove your innocence, but DHS refuses to take the parent off the abuse registry. Okay, my notes go on here and say Black's Law Dictionary. That's a book written up giving a lot of meanings and cases pertain to the courts. This dictionary stated, exclusive control of evidence. A party who has almost exclusive control of evidence gets to prove or disprove a fact will regularly be required to carry the burden on that issue. Anderson versus Sandberg. Equality will impose the loss on that party whose act first could have prevented the loss. Wickman, speaking for the DHS, had exclusive control of the evidence. And as I mentioned to the court, Santosky versus Kramer, that's a United States Supreme Court ruling. The DHS has the power to create history. Wickman is the attorney for the DHS, and she protects the DHS. DHS has the power to create history. That starts when they take your children, and then they make their own record, their own discovery, based on a lie, present it to the court. Well, sometimes I can understand why a judge would rule the way they do when they have the Attorney General and the DHS social workers lying to the judge. Well, on the other hand, why don't the judges wise up and realize what is happening to the people of the state of Iowa? And this doesn't just include the state of Iowa. It goes around the whole United States. We hear about it from all the states. It was the bar's ruling that there was newly discovered evidence. I then used the newly discovered evidence to file an action in court. That's what brought us up to today. It has now been 23 years since DHS stepped into my life and wrote 2 reports that have changed the course of history, totally destroying a family. One report was expunged in 1988. The DHS refuses to unfound and have expunged the second report, even though I had proven my innocence. Based on the DHS workers' own testimony in 2 days of trial that Wickman used all her power to keep from happening, kept me from trying to even get a hearing, because when I requested expungement, they denied that request. That's when I had to go to the district court, up to the Supreme Court, and the Supreme Court ordered that I had a right to a hearing. Parents, you have a right to a hearing. Don't let them tell you that you don't. The ALJ concluded in my case in 1990 that there was no abuse and the report must be expunged. He then said, take Don's name off the registry. Well, DHS has a way of sneaking around, and they changed my report to denial of critical care that had not existed up until the time of the hearing. Now, how can you have a denial of critical care report written after the fact when you have a hearing proving that there was no denial of critical care? DHS destroyed a family, but the positive side is my daughters are alive. I believe God is in control, and he has a purpose for allowing DHS to destroy my family. That's pretty hard to take, but that's the way I see it. John?
Okay, there was one quick thing before we turn the program over to our legal guru here. But the whole crux of this thing is that the attorney from the Attorney General's office decided that she would throw in something that was totally irrelevant. In other words, what your spouse does with your former spouse does in a child abuse administrative hearing has no merit whatsoever as to how your case is handled. They're handled completely separate. And then to bring that up as if it meant something to the ALJ, and the ALJ responded and did what he was instructed to do by the Attorney General's office. What kind of corruption is this? The administrative hearing process needs to be reformed. The DHS needs to be reformed. The courts need to be reformed. Would you like to hear how the courts should be reformed? Let's talk to a reformer, Terrance Walker.
Thanks a lot, John. Yeah, it does sound like a classic case of court corruption and courtmanship and lawyership. Not to speak bad about all lawyers and all judges, but that seems to be protocol in the courts, these games that they play, especially when it comes to less adept litigants, such as people that are representing themselves, like, Don or John or myself in a lot of instances. And I think this whole example epitomizes what I think goes on in the courts as it affects the average ordinary citizen. And I would like to summarize it by saying that it sounds like a classic example of false advertisement compounded by the bait and switch. And when I say false advertisement, I just want you to just think of an example where you were falsely advertised to, and you went to the establishment to get what you wanted, and they switcherooed on you. Say, for instance, you seen an advertisement for McDonald's. They had 5 hamburgers for $1, and you got there, and they wanted to only give you one for $1. And then, so you complain to the manager, and the manager says, well, we didn't know about that advertisement, but, here's your hamburger for $1. And this is exactly what is happening in this instance. Now, I know a lot of instances, most businesses will respect the customer, but when it comes to the judiciary, and the whole process that's involved there, and what we're advertised to on how it's supposed to proceed, when we get there and we find that it doesn't proceed the way that it's supposed to, we don't have anybody to complain to. There is no manager, because the manager is not in control. And manager is actually not on the customer side. There is no customer-oriented approach when it comes to the courts. So you go to the manager when it comes to the court system, and they're following their protocol and their procedures and the way that they conduct things, and you go to complain against them. Well, they're going to say, well, that's just the way the system is, and that's the way we're going to keep it, because we have a independent judiciary. So this is how we conduct our independent judiciary, by false advertisement and bait and switch. And a classic example of that, I thought there was an interesting article that came out in the Wisconsin Law Review, or Law Journal, on May 16th of this year. And it's basically a high five to the attorneys that were able to fend off a judicial accountability law in the state of South Dakota. The article is by David Ziemer. He starts off the article by saying, when the judiciary comes under attack, it is important to convince the business community, that they have the strongest interest in a stable court system. That was the lesson that Thomas Barnett, executive director of the State Bar of South Dakota, conveyed to the Wisconsin State Bar at its annual convention on May 9th. Although the judiciary has been under threat in this country since at least Marbury versus Madison, the worst it has gotten in Wisconsin is scurrilous demands for judges and justices to recuse themselves. But 2 years ago, in South Dakota, things went further, much further. A group calling itself JAIL, Judicial Accountability Initiative Law, led by California minister and frustrated pro se litigant Ron Branson, came up with a proposal called Jail for Judges that would strip judges of judicial immunity and even subject them to criminal sanctions. And this article goes on to state that the proposal, which was ultimately defeated at the polls by a margin of 89% to 11%, even though early polls show voters in favor of the proposal by margins of 3-1. and it goes on to basically applaud the efforts of Thomas Barnett, who, in my opinion, did a deceptive tactic in turning people against legislation that they were initially for by maligning the truth, and not only that, but by deceptively misrepresenting the law. And just to go back in a brief time in history, just to get a little history on the jail for judges law. Now, in 2005, the organization known as Jail for Judges, is JAIL, the number 4, and then judges. They're at JAIL for judges.org, as that has a website. They basically were successful in getting upwards of 100,000 signatures to get this initiative, which basically allowed penalties against wayward judges onto the ballot so that people could vote for whether or not this should be an amendment in South Dakota. And, well, this was, again, a classic example of false advertisement compounded by a bait and switch, because advertisement is that we, the people, have the power to make the law. We have the power to put initiatives on a ballot and vote for them as is. Well, the trickery that was done in this, as it pertains to this amendment, was that they not only deceptively misrepresented this to the business community and said this is be bad for business and this is going to be something that's going to make judges not respect the uniform commercial code, and you're going to be in lawsuits all the time if you're in business, and got the business community up in arms. But not only that, the Secretary of State was responsible for misrepresenting the law on the ballot, which is why early on people were in favor of something that was for judicial accountability and for correcting wayward judges, and for having 3 strikes if they had 3 bad instances of disregarding rights of people and doing wayward things in office. That 3 strikes, they would be stripped of their judicial immunity and even subject to criminal penalties, and are stripped of half of their retirement. Now, that it goes a long way from that to the actual definition that was put on the ballot by the Secretary of State of South Dakota in 2006. It goes a long way from what my initial explanation of the law is, to saying, well, citizens serving on juries, school boards, city councils, county commissions, or in similar capacities, and prosecutors and judges are all required to make judicial decisions. Their decisions may be reversed on appeal, or they may be removed from office for misconduct or by election. However, they cannot be made to pay money for damages for making decisions. This allows them to do their job without fear of threat or reprisal from either side. The proposed amendment to the state constitution would allow 13 volunteers to expose these decision makers to fines and jails and strip them of public insurance coverage up to 1/2 of their retirement benefits for making decisions which break rules defined by the volunteers. Volunteers are drawn from those who submit their names and registered voters. The proposed amendment is retroactive. The volunteers may penalize any decision maker still alive for decisions made many years ago. If approved, the proposed amendment will likely be challenged in court and may be declared to be in violation of the U.S. Constitution. If so, the state may be required to pay attorney's fees and costs. A vote yes will change the Constitution. A vote no will leave the Constitution as it is. Now, that is a very representative and deceptive description of what I've just read to you. And if you look at the actual jail proposal, it goes on in several paragraphs, and 3 or 4 of the paragraphs define the penalties for wayward judges, and it actually limits the penalties to judges. Now, that's a far cry from saying school boards and and public officials and all these other people that this description actually says. But for instance, paragraph 16 of the amendment, proposed amendment, says that the jury that is basically appointed or selected shall have the power to indict such a judge. As far as criminal penalties, in the next paragraph, it also says that a complaint for criminal conduct against a judge. And in the next paragraph, when it talks about removing, whenever any judge has received 3 strikes, the judge shall permanently remove from office. Now, that it says nothing in the absolute meat and potatoes of the actual proposal about any of these other officials, yet the state of South Dakota's Secretary of State was basically allowed to put in all this extraneous material and even argued on the ballot that it might be unconstitutional, and didn't even allow the people to decide for themselves whether it will be constitutional or not. That was something that would have, I think, would have been better suited for a court case than to actually put on the ballot that it might be unconstitutional and that it's unfair. If you're gonna put something on the ballot, if we're gonna advertise that we live in a democracy where we can actually put stuff on the ballot and vote for it, then I think we should be able to do that. Not have the powers that be, the judges and the officials and the attorneys in office who are supporting this independent notion of judiciary, have them misrepresent the whole issue to us so that we can be dumb about the whole thing and not be able to put it into effect. And one last thing here I thought was actually telling, and I'm reading this from this was a petition challenging the wording on the ballot before the ballot actually went into and was voted on in 2006. One of the judges who actually decided against the proposal proponents said in the decision, and again, this is on the the 4 judges.org's website. One of the guys that supported the petition and the amendment was Bill Stegmaier. Now, the judge in this case says, ironically, Stegmaier wants a judge to help him make it easier to sue judges. Stegmaier must have more confidence in the courts than he lets on in his public statements and his proposed constitutional amendment. In other words, we're not going to let you have us strip us of our powers. So, this is our answer to you. We're going to do what we want. And this is what happens with an independent judiciary. They do what they want. And that's why we've got the judge of the judges, and we're going to keep bringing it to you. We're even on Google, so Google us, Vocal Iowa, on Google, and we actually have several episodes online. So.
Okay, well, thank you, Terrance
Yep.
Walker. Here's some numbers that could be helpful to you if you're having a struggle with the Department of Human Services or the Iowa Juvenile Court system. We might be able to give you a few hints. We're not attorneys, but we'll give you a few free hints. How's that? See you next week.